Any mention?
May I please, Lordship, I beg to mention item number 13. After 2 weeks, Lordship, instruction is awaited.
13 at the request of the appellant, list after 3 weeks. 2 weeks.
2 weeks, Lordship.
Lordship, item number 7 and 8, Lordship, I was supposed to place the resolution, Lordship, adopted by the managing committee, Lordship. So I have filed the RTI, Lordship. I am yet to receive the copy of the resolution, Lordship. So I need another 3 weeks time, Lordship. In the meantime, I'll try to procure and file it.
RTA for what?
Lordship, what happened in this case, I have challenged the resolution, but inadvertently that resolution was not annexed with the writ petition, Lordship. Now the state respondent has said that since I have not challenged since I have not enclosed, so I cannot maintain that challenge against the resolution, Lordship. So
Otherwise, resolution is a part of the record.
no,
Has it
Lordship,
been
that
not
is why I'll place on record, Lordship.
This is 2018 case.
Yes, true,
So
Lordship.
if it is to be adjourned like this,
I have filed RTI, Lordship, on
you should have filed it before. Now after 6 years at the stage of hearing.
yes, Lord, because they have raised the issue.
No, that is, if you are challenging something, that should be a
True,
part of
true,
it.
Lordship. But in fact, the resolution, because the owner of the resolution, the master is the managing committee also.
Yes, madam, you do not have a copy of this thing.
No, Lordship.
You do not have a copy of
My
the
lord,
resolution. This is resolution by the managing committee.
Yes, Lordship, it is with the state respondent, Lordship. Even the managing committee also can place, because this is their document, Lordship. Even they have not annexed in the counter, Lordship.
When did you apply?
I applied this last, I think 1 or 2 weeks back, Lordship, after the matter was.
You do not know 1 or 2 weeks. What is the time frame under RTA for supply of?
30 days, that is why it is not over,
When
Lordship.
your 30 days will expire?
30 days, I think, Lordship,
week of
that
August, my
second
lord,
week of
it's
August,
second-
Lordship.
Somewhere second week, I believe.
Second.
Anyway, just say. We'll just adjourn it for 3 weeks.
My lord.
3 weeks, Lordship.
My lord, item number 9 is also
7 and 8, both.
My lord,
both the
7
matters.
and 8.
Because these are connected, Lordship. I am going to file in item number 7, Lordship.
All right, 7 and 8 at the request of the petitioner, list after 3 weeks. Yes.
9 is actually, you see, 9 is also connected. It is with the same issue, my lord, SSA school teachers, my lord. But the counsel for the petitioners are not here, so my lord. Mr. Sheikh is only for 7 and 8.
7 and 8, Lordship.
But then in absence of the counsel
My
of the
lord,
petitioner.
my lord, they are not here. So.
Yes.
May it please your Lordship. Lordship, I beg to make a mention of item number 11 on behalf of the petitioner. Can you have the matter after 2 weeks, my lord? I'll see the consent of the opposite party.
My lord, I'm for the state respondents, my lord. Mr. Sangma is for the
Also, private respondent.
private respondent.
So you can adjourn it.
My lord.
Lordship, actually, since
Well,
they are
this-
the petitioner. So, otherwise, this case is nothing survive because the trial is going on. Evidence is already being taken in the trial court. Nothing remains.
No, but then if they are successful in this
They
trial,
are not challenging the cognizance taken by the district judge after filing a charge sheet. There is he has taken a cognizance. That what they are not. They are only challenging the charge sheet. That part only.
but then if this writ petition is allowed, then what would happen? What would be the
The entire
Ultimate-
proceeding may go, but then yes,
so that is if the entire proceeding goes, then
yes.
Yes, my lord.
just at the request of the petitioner, list after 2 weeks. Yes.
Keep me obliged.
Master Lordship.
May it please your lordship.
Yes.
Your lordship, I beg to mention item number 6. Your lordship, we pray that this matter may come up after 2 weeks, your lordship, as the learned TSJ is not keeping well.
Lordship, I am for the petitioner, Your Lordship.
Yes, Mr.
No objection.
Learned DS
As soon as
is not well. So
Yes.
just a mention has been made on behalf of Dr. N. Majika, learned DSGI, to adjourn the matter by 2 weeks.
Much obliged.
The petitioner has no objection.
Obliged.
Prayer allowed, list after 2 weeks. Yes.
Your Lordship, can I beg item number 12? I pray for
Okay.
12.
Yes.
There's no
Since the,
objection.
What is that?
the conducting counsel is out of station, that's why.
This is a petition for quashing?
Yes, Lordship.
Yes.
Of what case?
This is this is a revision petition, Lordship.
Criminal revision.
Yes,
Against order of?
of judicial magistrate, chief judicial magistrate.
With
This is a
regard to
case of outraging of modesty, Lordship. So it is for quashing of that.
Okay. This also after 2 weeks. At the request made on behalf of Mr. Mahanto.
M. Lingdo.
At the request of the petitioner. Yes. Yes.
All right. To mention item number 3.
Yes.
I'm praying for respondent number 7, Your Lordship. Your Lordship, I'm praying for some accommodations since Mr. Pinongri is not available today. He's the leading counsel.
You are appearing for respondent number?
Respondent number 7.
This is a. Who is the petitioner?
Mr. Kipol, senior
That is a
advocate.
problem again.
They're not.
We cannot. You see, if the matter. Just be here.
We'll
Be here.
be here.
Just,
Supplementary cost list, item number 1.
May I please, Your Lordship, Lordship could recollect just on the 15th of June, I had withdrawn that criminal petition. This is regarding the same matter where the settlement has arrived between the petitioner, but the compromise deed is does not include the victims and all. I have recently executed, including all the parties, the victims and everyone, and they are all here, the petitioners, seeking quashing the criminal proceeding on settlement. Your Lordship.
and settlement.
Yes.
Yes.
Court has got power, no issue. Since
So
it's
you want that should be application, the petition be allowed, right?
not today, Lordship, at least notice will be
So that is what you see. You do not. You need instruction. So
an instance at least.
So we'll have it for these things. Heard Mr. Matma, learned counsel for the petitioner. Issue notice. Learned counsel for the petitioners. There are many things. Issue notice. Returnable in 3 weeks. Oh, there is only one respondent.
Only state. There is all party to the compromise date.
Along with so and so appears on behalf of the respondent. Start. List this matter after 3 weeks. Yes.
Item number 2.
Yes.
May I please, Your Lordship?
Yes.
Lordship, in this matter, day before yesterday, Your Lordship had asked me to find out from the judicial section whether the LCR is in a position to be returned back to the lower court.
Is it?
And the status of the paper
Oh,
book.
that is a
Paperbook
bail
is
matter.
ready. The paperbook is ready, Your Lordship.
Paperbook is
And
ready.
since the doctor's opinion is also that he should be released, and is
No, that is all that we can understand. The only difficulty was that,
since the LCR is
see,
here,
because this the bail bond and has to be accepted by the.
accepted by the
Yes.
trial court.
That is what the problem is. Your record remains here, then how it would be
So
possible?
since the paperbook is ready, Your Lordship,
No, but if we return back, have you checked the paperwork? Is it complete? Have you received a copy of this?
we have received a
Is it
copy.
complete in all this regard so that we can send back the record at least in such a
So,
case?
and then they should send it back to Your
It should
Lordship.
not be something like that. We send back the record and then you find deficiency.
No, what
Then
I
it will be
wanted
again
to say was this, Your Lordship, that paperbook is in our hand. We have not gone through the entire to see if we have, since we got it only
What is the
yesterday.
alternative? See, no, there should be an
No, it should
alternative.
be, LCR can be returned, bail bond accepted, and then it can be with a direction to them to return the LCR here, Your Lordship, after acceptance of the bail bond.
Okay. Yes. Art, Dr. P. Agarwal, Learned Counsel, appearing for the. This will be in this case 75. Can you? What is your instruction, madam? Just.
The doctor has also given, we had sought instructions as advised by Your Lordship, and then the doctor has said that on clinical examination of convict Sri Stephen Rambai, alias Khamkar Rambai, is suffering from APD, acid peptic disease, with amputated right upper limb and paralyzed left upper limb. The convict is unable to eat, drink, taking bath, etc. by himself. He was under medical care by the Medical and Health Officer, District Prison and Correctional Home, Joy. However, I strongly recommend for his
Same
release
thing
from
which has been appended with as
with
annexure-
earlier with this
annexure
thing.
one.
If
Please tell.
considered so that the convict can be taken care of by his family members outside this prison. Then
Okay. Hard Learned Counsel for the purpose. If it is the same thing, then it is
it's
not.
more or less the same, Your Lordship, except with the forwarding letter.
Okay, hard Learned Counsel for the parties. Hard so and so. Okay. Can you say? This is an application order. Section 389 within bracket 1 of the
Because of his
CRPC. Second CRPC for suspension of sentence. Suspension of order of sentence dated 1810 to
23.
2023 passed by the learned session judge.
Clear yet?
This is a POXO case. Is it a
Not,
POXO case?
No, Lordship.
It's Dacoity, Your Lordship.
Session judge stroke additional DC within bracket judicial. Iska Cell District.
Is Jaintia Hills.
Yes, pardon.
Giant Hills, Your Lordship.
Is Jaintia.
East Jaintia Hills, sorry. Yes, East Jaintia Hills District. Comma credit in session case number 24 of 2021. Whereby the applicant was directed to undergo 7 years rigorous imprisonment in consequent to his conviction under section 397 IPC. Give a paragraph. The learned counsel for the applicant submitted that the health condition of the applicant is not well, and deteriorate to such an extent that his proper care cannot be taken inside the jail. The Learned Council draws attention of the school to the medical status report issued by the medical and health officer, district prison and correctional home, West Jaintia Hills District, Juai.
Dated 16/7, Your Lordship.
Dated 16/5/2024.
7/2000.
16 May.
The latest after we received the instruction is 16
That will
July.
Just, no, just we'll just go by this thing. 16 May.
Okay.
2024. Because we are referring to their petition. Dated 16 May 2021. Whereby it was stated that the convict, you say applicant, do not say convict, is unable to eat, drink, taking bath. Whereby it is stated that the right hand of the applicant was amputated and his left hand was paralyzed. Stop. The applicant is unable to eat, drink, taking bath, etc. by himself. The Learned Council also points out that it was strongly recommended therein that the appellant should be released from the prison so that he can be taken care of by his family members outside the prison. What happened?
There was some technical glitch.
It's all right. It's all right. That's the problem with the Learned Council submits that considering the medical situation of the appellant, he may be the sentence, the order of sentence passed against it, and he may be released on bail. Stop. Give paragraph. MST Youngie, Learned AG, appearing for the state, does not dispute the submission made on behalf of the applicant, and further submits that it is indeed difficult.
Another circumstance.
It is indeed difficult for the jail authorities to take proper care of the applicant. The Learned AG on instruction does not oppose the prayer of suspension of sentence in the matter. Your paragraph. In view of the above, it is deemed appropriate at this stage to suspend the order of sentence dated so and so. Just see from
18/10/23, Your Lordship.
and direct the release of the applicant on bail.
Some terms and conditions may be imposed, Your Lordship.
Terms and conditions, what much? You see, like, he should not leave the
Jurisdiction of the court.
statement is to be taken out.
That is a different matter. That is
either the court or the concerned police station.
That is all, Your Lordship. let him take
If
permission.
his release is for purpose of health ground, then it may happen like that they may take him to Guwahati or somewhere for treatment.
Then in that case, they can
We'll just make clear it that
Yes.
wherever they move, then
Yes, Your Lordship.
just what was the last time? During the release of the applicant on bail. Accordingly, the order of sentence is so and so shall remain suspended till the final outcome of the criminal appeal number. What is the thing?
19 of 2024, Your Lordship.
And the appellant be released on bail on furnishing of his bail bond of rupees 20,000 with a surety of like amount. Applicant shall not leave the jurisdiction of the trial court without informing. That is,
Yes, that is
which shall trial court or the concerned police station? What would be better? I think concerned police station
Police
will be,
station should also do, Your Lordship.
because if the record remains here every now and then going and
Yes.
approaching trial court, that will be all right, madam, for you. I think let him.
Again, he's gone.
The what you said the last line. Without prior information. Without giving prior information to the concerned police station. The LCR record called for by this court in connection with the criminal appeal may be returned back to the trial court to facilitate acceptance
Bail bond.
of bail bond of the applicant. Stop. The LCR record be remitted back to this court immediately after the acceptance.
Yes, of the bond.
Immediately after the completion of the formalities of acceptance of bail.
That's
Stop. We just say this application stands with the above. This application stands disposed of. Is it all right?
Thank you, Obliged Lordship.
Obliged, Your Lordship.
You take back your thing. Yes. Yes.
Daily causeless, item number 1.
As per the last order, the petitioner was supposed to make some correction.
We made the correction, Your Lordship.
What is the correction needed to be made?
Your Lordship, the affidavit, the paragraphs were not filled in the missed case, so we have filled that out.
So you have done it.
Yes, yes.
You filled up those blank.
We filled.
Okay. Yes.
Your
What's the
Lordship,
matter about?
Lordship, I'm before this court challenging the order of the trial court when they had proceeded for framing of charge and rejected my prayer for discharge. Now, Your Lordship, the provision.
Framing of charge under what section?
Lordship, is 227 of CRPC.
302, my lord.
The offence is 302.
302.
Yes, Your Lordship.
He's been charged under 302.
302.
Then
Others-
302.
Yes, Lordship.
This is a heavy burden on you.
Yes, Your Lordship.
Charge sheet doesn't say anything against you.
Your Lordship, in my submission, the only evidence that is available against me, against the petitioner is CDR, Your Lordship. And merely on the basis of CDR, the case has proceeded, Your Lordship.
You understood? But the sufficiency and insufficiency of evidence is no matter at this stage.
Your Lordship, my submission CDR is merely a corroborative piece of evidence
Well, it
that has
may
to
be,
be
it
corroborated
may be,
with other
it may be.
independent. Your Lordship, none of the witness has stated against anything against me, Your Lordship.
Sir, see, only thing what law requires is that if you can make out a case by which we can say the petitioner is not guilty.
Your Lordship, I'll try
It's
to.
a kind of a reverse burden, you see,
Your
at this
Lordship,
stage.
here, Your Lordship, even the how they've connected me to the crime, I'll just give a brief submission, Your Lordship. How they've connected me to the crime, Your Lordship, is that there was a prime accused, Your Lordship, a well-known accused person known as I Love You Taryang. He has expired prior to filing of the charge sheet. So I was the only person along with another accused who has proceeded with the trial. Now, Your Lordship, the victim herein, the phone was found from the place of occurrence. Now, from that phone of the victim, Your Lordship, a phone number was recovered. Now, Your Lordship, the investigating authority stated that this last contacted number belongs to the prime accused, I Love You Taryang. Now, Your Lordship, even though if it's believed that's true, the number phone which the investigating authority is saying that belongs to I Love You, in the charge sheet itself.
The name of the prime accused is I Love You.
Yes, Your Lordship.
Why he is involved in murder?
He's a very well-known accused, Your Lordship. He was lynched to that also, Your Lordship,
Why you
while he was escaping from the jail.
happy with his name?
I'm not aware, Your Lordship. So, Your Lordship, the phone number which was recovered from the phone of the accused victim was linked to this person known as I Love You. Now, however, Your Lordship, in the charge sheet itself, it's clearly stated that the number which they saying it belongs to I Love You is not even in the name of the prime accused, I Love You Taryang. Now, Your Lordship, from the phone of that accused person, they have stated that they have found that I have been in contact with that person. Now, the problem lies here in, Your Lordship, the phone itself, which is the primary piece of evidence, was never recovered.
That we'll see at the stage of trial. How
Your
they
Lordship,
establish.
now, if offence itself is not linked, Your Lordship, to the prime accused, then Your Lordship, how can it be linked to me? And Your Lordship, furthermore, Your Lordship, I do not have any phone with myself, Your Lordship, and that is also part of the charge sheet, that I do not possess a phone. Yet, Your Lordship, they came to a conclusion that I had been in contact.
Mr. Pasa, you have a huge burden to discharge at this stage. What you are pointing out is with regard to the loopholes of the prosecution case, the weakness of their evidence. But then that doesn't wash off the allegation which is made against you in the charge sheet.
Another aspect that there were 5 suspects, but the charge has been drawn against only 2.
That is all right. That is all right. But then you are named there. That is the main thing. Now, you see, you may even say that, you see, the list of witnesses given or these things, they also do not disclose anything in this. But then the thing is that the IO is a vital witness in this matter. It is an investigation of that person which has linked you to this. Now, his investigation, which he connects that severe thing with you, this is to be seen. And that is to be seen at the stage of trial.
Your Lordship,
we cannot just say that this piece of evidence is not worth proving in the trial. We cannot say it.
Lordship, my humble submission, if I had possessed a phone at the time of commission of the offence, and even with the tower location showed my actual positioning at the time of the offence in that particular area, which has been done to the other accused, I would have not filed this revision, Your Lordship. But Your Lordship, I do not even possess a phone.
This is all right, but then you have been connected some.
And Your Lordship, they've relied on the statement made, allegedly made by my wife. But Your Lordship, there is no 161 statement or 164 statement, Your Lordship.
See, there at this stage, it may appear that there is no direct evidence against you, but then we cannot rule out of appearance of direct evidence against you in the trial. At least something indirect is there against you, if not direct. We understand. But then to seek quashing 302, you have to basically show that whatever there is in charge sheet, if it is accepted also, that will not result in conviction. And that is very difficult.
Yes, that's why
that is the proposition of law. It is up to you. Whatever you do, it's up to you. Yes, Mr. Gurung, what do you say?
My lord is absolutely correct, but what my friend has projected right now, my lord, it is only on the basis of CDR, my lord, analysis. No, that is not the case, my lord. Here, what has happened, my lord? There are two men accused, my lord.
Mr. Pastor, yes, it's
I love you, Talang, and another Mr. Dhar, my lord. He is absolutely correct that the present accused had no mobile, my lord. But the wife revealed, my lord, during questioning interrogation by the IO, my lord, that my wife had left with the men accused, I love you, Talang. And in order to, because he did not came on their particular...
wife revealed that my husband has, not
Yeah.
my wife.
Lord, my husband did not return, but I knew he had moved with Mr. I love you, Talang, the man accused, and did not return the night on the night of the occurrence, my lord.
That appears to be an additional evidence.
Exactly, my lord.
Lordship, that statement given by my wife is neither recorded under 161 or 164. And I've not even served a copy of either of that.
But then if it is there, if it appears to be there,
It is in the charge sheet, my
Even
lord.
the wife
allow
itself
it
is
to
not
be
named
proved
as a
at
witness,
this
your
court?
lordship. My wife has not been named as a witness in this case.
See, 311 is there. Holds power, white power is there. See, only thing is that, more you argue, you see, it is due respect. There is no problem for this court allowing you to argue. More you argue, more you will be exposing your strong point to the prosecution. You will be making your own case weak. Now, that is what the problem is at this stage. Now, if you argue on many points and if you want this court to give a finding, there is no problem for this court. But then, do you think that will help you in the trial, at the stage of trial, if you are unsuccessful in this case? Every point you raise, they will try to cover it up in their trial. So you will be showing you will be exposing all your weapons at this stage, weapons of defense at this stage. It's up to you. It's up to you.
That is basically my entire case. And your lordship, in the impugn order, there are certain errors made by the trial court where it has recorded certain things which are not even part of the charge sheet, where it has stated that my location is at the place of the occurrence at the time of the incidents. When your lordship, I do not even have a phone. So I don't understand under what basis that finding was arrived at by the trial court, your lordship.
Okay, we'll issue notice. Give him one more day at least.
Your lordship, I'll just try to satisfy. I'll bring some judgment, your lordship.
Definitely. It will be too harsh on him to reject it at this stage. Hard, Mr. A Pasa, isn't it?
A Pasa.
A Pasa. Learned counsel for the petitioner. Issue notice. Returnable in 3 weeks. Mr. Gurung. Learned GA. APS.
One, my lord, for one.
One. How many respondents are there?
There are two, my lord.
Two is the complainant, your lordship.
Yes. Give a stop. The petitioner shall take steps for service of notice upon the respondent number 2 within 2 days. At least after 3 weeks.
Your lordship, there's a interim prayer, lordship, because
This court is not even inclined to issue notice in this kind of.
Lordship, because the stages for framing of charge.
Doesn't matter. If you are successful here, that whatever is happens, that will go.
Lordship, only till the next date, your lordship, because we'll try to complete that day.
Will not disturb. Sorry.
Deeply obliged.
Item number 2.
It's a man who appears on one day, the next day he is absent, then again. From which date, madam, it is pending for taking of steps upon? From when is the first day?
Your Honor. Your Honor, from the month of April.
What is the order dated 8/3/2000?
Lordship, on the 31st of May, there was a prayer.
Yes, order dated 8/3, I think. There was a prayer for taking of fresh steps.
Yes, my lord.
And then thereafter he has not taken.
There was another order on the 31st of May. In respect of private respondents number 3, 5, 7 and 8, the petitioner submits that he may be allowed some time.
35 or 25, 6, 7, 8?
Lordship, in the order dated 31st May, it is 3, 5, 7 and 8.
Order dated 31st May. Yes.
3, 5, 7 and 8.
Yes. Okay. Okay.
And here also respondent
appearing-
number 6 is not mentioned.
Yes, madam, you are appearing for respondent number 4.
Yes.
How many respondents are there altogether?
8.
1 and 2 are state respondents.
States. 4 is present and 3, 5, 6, 7 and 8 missing. And there was no order pertaining respondent number 6.
Then affidavit of service has been filed in respect of 2, 5, 6, 7, 8.
Then 3 goes missing, my lords. If it is 2, 5, 6, 7, 8, then we still do not have respondent number 3 on board.
Respondent number 2 is who? Again, 2 it is not state then.
Your Honor, 2 is not the state. He's the main accused.
Four has appeared, 3 is not there.
Two, 3, 5, 6, 7, 8. You're only
Anyway, we'll just give one more chance. None appears for the petitioner. Record their name, so and so and so and so are present on behalf of the respondent number. Shyam will be
respondent number
respondent
1.
number 1. And MS, shut up. Yes, for respondent number 4. Wait, see, what is this? This is, she's appearing for respondent number 4, not respondent number 2. You should be careful about those things. You are appearing with along with Mr. S. Pandey.
Yes, Your Lordship.
Okay, so this is my pen for this thing. The what is it? None appear for this thing. No, 9 appears. So the office note indicates that step has not been taken for service of notice upon the restaurant number 5 to 8. Best of you have Then after, I just list this matter after 1 week. In the meanwhile, the petitioner shall take steps for service of notice upon the respondent number 528, 5678. Yes.
Supplementary causeless. Item number 4.
Yes.
Your Lordship, the senior counsel is on his legs, Lordship, as he's engaged in one hearing matter in courtroom number 2. I'm bringing this matter may come on Friday, Lordship.
Next week. Friday. We'll have it next week. Friday is quite uncertain, you see, that being the last day is not a good day for hearing. That is known traditionally here. Yes, just at the request of the petitioner, list this matter in the next week.
Next week.
We'll have it in the next week.
I do pledge.
The only thing is that you'll have to again remind the court about the things. That's the problem. Anyway, it's concerned section 9 only. Section 9.
Yes.
Daily causeless. Item number 3.
Yes.
Your Lordship, in this matter, I'm praying for time on behalf of Mr. P. Nongri.
P. Nongri
Yes,
is
sir.
appearing for respondent number?
Respondent 7.
What happened? What happened to him?
Your Lordship is not available today, Your Lordship. He has some personal difficulties.
He has got a better case somewhere else.
No, Your Lordship.
Yes, madam.
Lordship, no objection.
When do you want it?
Sure, after 2 weeks.
I'm applying for respondent number 1 to 6.
You're opposing spare? No, not opposing. Okay. Yes, Mr. A. Pasa, Learned Counsel, makes a prayer on behalf of Mr. P. Nongri, Learned Counsel, for Learned Counsel for
Respondent 7, Your Lordship.
Respondent 7. Learned Counsel appearing for Respondent 7 to adjourn the matter on the ground of non-availability. And to adjourn the matter, just only adjourn the matter. Yes, give us time. The prayer made has not been objected by the Learned Counsel for the petitioner. The prayer allowed, list after 2 weeks. We'll have it after 2 weeks.
Lordship, 3 and 4 are connected.
For the item 4 also similar prayer. For
You're appearing in all the matters as respondent number 7.
No, Your Respondent number 4 in this next matter.
Next matter, his submission will come as a counsel for the respondent number same. Mr. Nongri is appearing.
Yes.
Same matter. And then? Yes. You are for the petitioner in all these matters?
Your Lordship.
And,
Your Lordship, I'm applying for respondent 1 to 3 in this matter.
okay, there are 2 matters.
Two matters.
You are only expert of 7. Do not commit a mistake. Be.
Oblige, Your Lordship.
Item number 5.
My lord, my sincerest apology, my lord.
Yes.
I'm praying for some more time, my lord. In spite of my repeated, my lord, WT message, no instructions are forthcoming.
What is this matter about?
My lord, there was a direction to the state respondent to seek clarification as to the percentage of reservation in respect of a special category, my lord. So, my lord, today I am sending another very strong WT message for his personal thing, my lord.
How strong it will be? No, you have to be. Sometimes it happens because this court also has functioned in your capacity.
My lord, my lord.
And know how to make them move. You also should adopt the same way. Yes, madam.
No objection.
2 weeks.
My lord.
Yes, at the request of Mr. Guru, Learned GA, list this matter after 2 weeks.
Highly obliged.
Item number 9.
Lordship, in this matter, I'm praying for some time.
What is the matter about?
Lordship, this regarding
Lordship, regarding non-sanction post of teacher, Lordship,
It's regarding Hindi teacher. It's the same case.
with item number 7 and 8.
This is post is with regard to the appointment of Hindi teacher, SSS school. And what is the dispute? What is the nature of dispute? The petitioner was ousted from there. There are 3 cases concerning the same post.
No, not
Different
schools,
school.
but the post is same, not Hindi teacher.
So these are
Now the question is whether Hindi teacher is a sanctioned post or not. So our stand is that it's not a sanction.
but there is a language teacher, isn't it?
Language teacher.
Now what is a language teacher?
Language teacher will be not the local languages, whether it is Bengali, Assamese, these languages. Other than Hindi.
English is not a language teacher.
My lord, you
See, language teacher, it should be either the mother tongue of the people or the language spoken in the area. And it can also be English, Hindi, depending on the situation. So you just cannot say that Hindi teacher is not a language post until and unless that is expressly said so. Now, if you say there's a language teacher, then you have to specify the language, which language.
So the local language.
Local language means what? Local language is something, it should be Khasi, Garo, or
Yes, my lord. Khasi, Garo.
yes. Now
Then
for this school,
some
what is the language teacher?
Language teacher will be.
Do not say will be. What the record says. It's not your assumption, not our assumption. Just because you see like there's a population of Khasi people around, it just cannot be a presumption. It can be English also, because the school may desire to have an English teacher. And when do you want it, madam?
Lordship, after 2 weeks.
Your Lordship, I pray it may be fixed along with those another matter which are related.
If this are not concerning the same issue, why should we be allowing it?
So far it's been listed same together.
It's coming up same together, and then the same prayer is made in the other matters also. Who are appearing other matters?
The other matters, Mr. Sheikh is the
Petitioner.
counsel.
7 and
He's not here.
must have mentioned, Your Lordship.
He mentioned that matter.
Mentioned. It must have been mentioned, Your Lordship, in the morning.
Must have been mentioned. I don't know what.
It was mentioned. It was mentioned. Your
I
Lordship.
don't know what.
7 and 8.
When it is coming up, 7 and 8.
After 3 weeks.
So this also should come up after 3 weeks.
3 weeks.
And the request made by the petitioner, this is made after 3 weeks. You see, just so that it comes up on the same day along with those. Yes.
Highly obliged.
Highly obliged.
Item number 10.
Yes.
Your Lordship, I have similar prayer, Your Lordship, in this matter.
What's the matter about, Mr. Nangre?
Lord, this is recruitment, Lord, of Ayush doctor, Lord.
Ayush doctor.
Yes, Lord, by MPSC.
By MPSC.
Yes, Lord. So the petitioner was
Ayush doctors are recruited by the state.
Yes, Lord, by the state government.
And what is the dispute? What is the
Ayurvedic
dispute here?
Dispute, what happened, Lord, the entire process was completed, my Lord. After the interview was...
You offered your candidature.
Yes, my Lord. I was successful, my Lord, number 2. And there were complaints from other candidates who were unsuccessful, that one of the members of the interview board is of the same title, my Lord, of the same, are related.
The same clan.
Yes, my Lord, Lalu, my Lord.
Yes.
So an inquiry was conducted by them, and it was found that they have no relation. They are not related. It's just not just a clan, same clan. Thereafter, my Lord,
that is your case. Is it?
That is my case, my Lord.
You are appearing for the MPSC or
MPSC.
for
MPSC. Mr. Paul is the
there
main
is no other
respondent.
private party in this case.
No private parties.
How many persons were there in the select list?
Select list, my Lord.
There were more than 2, or
More than 2 for interview. They were like, because the complaint was filed by.
none others have approached.
Yes.
You are the only person.
Yes.
And what happened subsequent to that, after scrapping of that? What happened to the post now?
My lord, after that, since the 2015,
When this thing selection process was scrapped?
this was, my lord, in 2016-17. Advertisement was 2016, and it was scrapped during the same year itself, my lord. But
What is you are challenging any order? Passed.
yes, my lord.
What is the impugned order? Dated
24th of May 2017, my lord.
2017. Now challenge was made in 2020.
Yes, my lord. My lord, in between, no, my lord. Challenge was made immediately, my lord. Challenge was made immediately. Now, the matter was decided by the single bench, Honorable Justice Sen, my lord. Then the matter, my lord, there was no division bench available. So we approached the Supreme Court. The matter was transferred to the division bench of the Honorable Guwahati High Court. There, my lord, we withdrew the proceedings because two orders were not challenged, with liberty to file afresh. So we have filed afresh, my lord, in 2020 after withdrawing. So that is where we are, my lord.
That is how the delay occurred.
Yes, my lord.
Now, what development took place in that 3 years about the post?
No recruitment till date, my lord.
Lordship, due to the pendency of this matter, there's no recruitment.
So that post remains vacant.
It remains vacant.
Various posts, my lord. In fact, as on today, there's been no recruitment for the last 7-8 years. So there are a lot of.
You are concerned with that?
Yes, I'm concerned only with that advertisement.
Ayush doctor.
Yes, my lord. Ayurvedic, my lord.
Yes. When?
Lordship, after 2 weeks.
Lord.
The petitioner is working somewhere now.
My lord, they are working with the state government, but under contractual.
Not in expected position.
No.
You are appearing for? Who is appearing? There is no state.
State government is a party, my lord.
No representation.
Miss Colony has been appearing.
She is not there.
Respondent number 3 is the state government.
The parties do not bother to appear. In spite of so many government advocates in the panel, you do not bother to. We can understand that one may have difficulty. See, that becomes the person who holds the brief knows the best. At least make sure that you appear. If you do not appear, then we will write to the department. No, you see, the one thing, Mr. Bhattacharya, please listen, don't mind it. This court was on the other side for about 3 decades. Never defaulted in appearance. That is the worst thing for our profession. You are prepared, you are not prepared, okay, all right, we accommodate submission and make it. But then to default in appearance, this is something very unprofessional. Yes, the request of
1 and 2, my lord.
And the request made on behalf of respondent number 1 and 2, list is made after 2 weeks. Nothing more.